Well, hello and welcome everybody to our employment law update session today. Thank you so much for joining us. Delighted to say I'm joined by my colleague Morag Moffett today. Right, yes, what is the purpose of this session? Let's get into it. So I think, well, many of you will have joined us in the COVID-19 sessions that we did, and we found that went down really well, and people enjoyed kind of jumping on these 1 hour updates and hearing what's going on. So we thought what we would do is try and do regular WebExes like this that coincide with our employment law lab bulletin that we publish. So we publish that bulletin every couple of months, and we thought we would do WebExes around the same time as well, covering some of the topics that will be in the bulletin. Obviously, if there's other developments in between the bi-monthly updates, then we'll set up WebExes to cover those as well. But really the purpose of this session is to get you up to speed with recent developments as much as possible. There will be a little bit on COVID-19, but that's not all we'll focus on for the purposes of today. So structure for today, we're going to start off by looking at 3 key cases, one on redundancy scoring and selection, obviously highly topical at the moment, sadly, one on reasonable adjustments, and one on witness anonymity in disciplinary hearings. So we'll look at those 3 cases first. Morag is then going to do a bit on virtual tribunal hearings and top tips for preparing for virtual tribunal hearings. What is becoming very apparent is that the tribunal system will be using virtual hearings for quite some time. It's not going to just be in the next kind of few months. I think it's going to be our new normal, so it'd be helpful just to chat through some issues on that. The third section we'll look at then is some COVID-19 developments, and then finally we'll just pick up on some other points under other news as a category. So that's your structure for today. I hope that all makes sense. I'm going to kick off with the 3 cases, starting with the redundancy scoring and selection case. So this is an EAT decision that came out recently. The case itself is called Gwynedd Council against Barrett and others. And it deals with that scenario, very common scenario, where you hear people talking about the fact that they've been asked to reapply for their job in a redundancy process. And the question in the Gwynedd Council case is whether it's fair to use competitive interview processes in a redundancy exercise. So I'll start off just by giving you some of the facts for the background to this case. Excuse me. What happened here was there were 6 schools in a particular area, and a decision was taken to close all of the 6 schools and pull all of the pupils together in one school. And so the process that was followed was that the teachers in each of the schools were told that the roles within their existing school was no longer there, and that they would have to apply for a role at the new school. And so that was the process that they were required to follow. So there were 2, the claimants were both PE teachers. They both took part in a competitive interview process in order to get a role as a PE teacher at the new school. Neither of them were successful in their application, and therefore they were made redundant. And they were not given any right of appeal against that decision to make them redundant. And what's really important in this case, and the kind of key point, is this distinction between what kind of selection process you can adopt in a redundancy exercise. So those of you that joined us on the redundancy sessions where we spoke before, we talked about if you've got a pool of people and you're applying selection criteria, your obligation is to try and apply criteria that is as objective as possible. So it's not about choosing people based on subjective interview criteria. It's about choosing people based on objective criteria, like first in, last out, disciplinary, these sorts of issues, rather than sort of select subjective criteria. So the key issue in this case is the I'm trying to get it back into my head now. The key issue in this case is when the employer was going through the process, what they did was they said to the employees, you have to effectively take part in a competitive interview process for your role. And what the Employment Tribunal said, and it was upheld by the Employment Appeal Tribunal as well, was that is not a fair process. It's okay to use subjective interview type criteria if the situation is that the employee's existing role has been made redundant and they're being given the opportunity to apply for an alternative role, for a suitable alternative which is different to their existing role. Whereas in this case, what the employees were effectively doing is they were PE teachers in the school that they were in before. The role that was being advertised in the new school was again for a PE teacher. It was exactly the same role as the role before, and therefore the employer could not then use that kind of subjective criteria in that interview process in order to identify who was going to be placed in the new role. So there's a distinction between whether you are selecting people in a pool. If you're going down from, say, 5 to 4, then you have to apply that very objective criteria. That's quite different from once you've identified individuals who are at risk of redundancy and you're giving them the opportunity to apply for a suitable alternative. If they're applying for a suitable alternative, then you can use a competitive interview process and subjective criteria. So the tribunal in this case decided that the process that was used by the employer, where they just effectively went straight into the competitive interview process, they didn't do the objective selection process, the tribunal said, well, that's unfair, that's not a reasonable process, and therefore it's an unfair dismissal. They also criticised the employer because there was no consultation with the staff really in relation to the redundancy process and how that was going to be followed through. They were just told that they had to apply for their own jobs effectively in the new school, and they said that that also meant it was unfair. But the final point, which I think is quite an important point as well, is this issue of whether or not you always have to give employees who are placed at risk of redundancy a right of appeal. And one of the basis upon which the claimants claimed their dismissal was unfair because they said they had no right of appeal. Now, many of you will know that from a legal point of view, there's no requirement to give employees a right of appeal in a redundancy situation. As long as you go through your consultation, you don't have to offer a right of appeal. However, many of you will have built into your own processes a right of appeal, and it's quite a useful thing to do if, for example, you feel that something's gone wrong in your process prior to the appeal. The appeal gives you an opportunity to try to resolve that and to try to fix that, but there's no legal obligation to offer a right of appeal, subject to your own policies. If your policy says you will offer an appeal, then you should follow through on that. However, again, in this case, what the tribunal said is, because the process itself was so unfair in terms of how the selection took place, the fact that there was no appeal as well was something else that weighed into the sort of overall unfairness of the decision to make the redundancy. So whilst there's no legal obligation to offer an appeal, if your process generally has flaws in it, the fact that you've not offered an appeal will be something else that will be taken into account and likely to result in a decision that any dismissal was unfair. One thing to think about there within your own policies, if you don't have anything, if you don't have a redundancy policy and so you don't say whether you offer a right of appeal or not, then you can decide on a case-by-case basis whether or not you want to offer a right of appeal in a redundancy process. If you do have a policy that says that you will always offer a right of appeal, you might want to give some thought to whether or not you look to change that. And obviously, if it's a contractual policy, then you would need to get agreement to any change. But the thought process behind not offering a right of appeal in a redundancy situation is really out of a desire to offer, if there are other people that have been involved in the redundancy consultation, to offer them some sort of certainty. Because if they've been advised that they're okay and they've not been selected for redundancy, if you say to them, but the person that has a right of appeal, so it's subject to the outcome of that appeal, that can create quite a period of uncertainty for the individuals that have been told that they're not at risk of redundancy. So that's why there's kind of no obligation to offer a right of appeal. But you might, as I say, check your own policy, see what your own policy says. But what you could write into your own policy is that in practice, you don't offer a right of appeal in a redundancy situation out of that kind of desire to give certainty to other people that were involved in the redundancy process. However, if the individual has serious concerns about the decision to terminate their employment on the grounds of redundancy, they should let you know, say within 3 working days of getting the decision. and you may then decide to offer a right of appeal. And what that does is it gives you that discretion whether you want to offer an appeal or not in each redundancy scenario. And it also gives you the ability, if you feel that there has been problems with the redundancy process, it gives you an ability to offer an appeal and try and resolve some of those issues, should that be a concern for you. Okay. So 2 points from that. One, no, you can't select employees for redundancy based on a competitive interview process. You can select individuals for alternative roles, provided the alternative role is sufficiently different from the role that they were doing before. You can use competitive interviews there. And the second point is, whilst there's not a legal obligation to offer a right of appeal in redundancy, if your process has been messy, it's likely to be another factor that's taken into account in a decision that the process has been an unfair dismissal. Okay. Just a question that's come up there, is it safe to use interview where there is no objective criteria to use, i.e. no absence or disciplinary cases and a subjective performance review process? You can use desktop interviews in order to or an interview process or a desktop interview process in order to carry out your selection if you've got a pool and you're going from, as I talked about before, say 5 down to 4. An interview can be part of the process. The risk with that, though, is that you're moving into that area where your decision is very subjective and is based on who you like, and you're thinking about the future of the role rather than it being an objective process. So if you are going to use interview as part of that initial selection, I would recommend that you build in as much or as many objective criteria as you can in addition to the interview. And the other thing that you might want to think about is having more than one individual carry out that interview process, so that if you're criticised for the process that you've followed on the grounds of, well, that manager never liked me and so they were always going to select me, if you can demonstrate that more than one manager was involved in the interview process, then that helps with that. But my advice generally to you would be steer away from an interview when you're looking at the selection from the pool, but certainly you can use an interview when you're looking at deciding who might be given any alternative position once their existing role has been deemed as redundant. Okay. So that's redundancy scoring, selection and appeal. The next case I want to cover is a really interesting case. I think it's all to do with disability discrimination and reasonable adjustments. It's the case of Hill against Lloyd's Bank. And again, this is an Employment Appeal Tribunal decision. And this whole issue of how far should an employer go when it comes down to the duty to make reasonable adjustments is a very kind of difficult issue for employers to decide. And the way the case law has been going on this over a period of time is there's a real expectation on employers to go pretty far when it comes to making reasonable adjustments. There was a case a few years ago now that spoke about, even if the employer thinks there's a small chance, just a small chance, that adjustment will enable the individual to stay in their role if they're suffering from a disability, then that's enough for it to be a reasonable adjustment that the employer has to make. And you'll know the kind of things that the tribunals take into account when they're looking at whether or not something is a reasonable adjustment will be things like, well, what is the cost for the organisation of putting that adjustment in place? How likely is it that that adjustment will enable the employee to carry on performing their role? And also, one of the other key criteria is, what impact will that adjustment have on the business's ability to carry out their functions? How big an impact will it have on the employer's ability to do what the employer is there to do? So these are the kind of factors that the tribunal will take into account. But in the case of Hill against Lloyd's Bank, the question here was whether it was a reasonable adjustment for an employer to give an undertaking to an employee that if that employee, so the employee had raised an allegation of bullying against one colleague, but had also kind of indicated that there was an allegation of bullying against another colleague. And what Mrs. Hill wanted Lloyd's Bank to do was to give an undertaking that she would never have to work with the two colleagues that she had said had subjected her to bullying and harassment in the workplace. And if at any point in the future due to a restructure or whatever, Mrs. Hill did have to work with either of those individuals, then the bank would allow her to leave and that she would be entitled to receive enhanced severance terms. So that was the reasonable adjustment that Mrs. Hill was asking Lloyd's Bank to make, that they would give that undertaking that she would never have to work with those two individuals at any point in the future. And if, as a result of any sort of reorganisation, she did end up working with them, then she had the right to receive a severance payment and leave the bank. Okay, so quite an interesting one in terms of a reasonable adjustment. I do wonder how many of you on this call are thinking, there's no way we would agree to that, and that maybe gives a bit of an indication about where this case went. I'll tell you a wee bit more about the facts first before I let you know the decision. I suppose it's important to note that Mrs. Hill was employed for 30 years by Lloyd's Bank, so she had been there for a long period of time, and that is one of the factors that tribunals will take into account. She had been off sick for a period of 18 months as a result of stress and depression. And the reason she said that she was suffering from that stress and depression was because she had been subject to bullying by two of her colleagues while she was at work. Again, it's quite important to note here, it's interesting to note here that Mrs. Hill submitted a grievance, but only against one of those colleagues, not against both, but she submitted a grievance alleging bullying and harassment against one of her colleagues. That grievance wasn't upheld, and she appealed against that outcome, and the appeal wasn't upheld either. So there had been a grievance that she'd been bullied in the workplace, and that grievance wasn't upheld. Okay. When it came to her return to work, and again, this is a very common scenario and one probably a number of you will have experienced, she said that she did not want to work with those two colleagues when she returned. And actually, the two colleagues also said they didn't want to work in the same team as Mrs. Hill when she came back to work. So at the time of her return to work, it was agreed that she would work in a different location from those two individuals. So when she was returning, she was going to be working elsewhere. She wouldn't have any contact with the two individuals. But in addition to that, this is when Mrs. Hill said, well, as a further reasonable adjustment that I think you should make, you should give me this undertaking that I'll never have to work with them, and if I ever do, then I'm entitled to a severance payment and I can leave the organisation. And what she said was the thought of ever having to work with those two individuals filled her with absolute dread and fear. And she had this real kind of concern about the future. So although she wasn't working with either of them, she still had this fear and dread about the future and the possibility that she might have to work with them in the future. And it was for that reason that she requested that undertaking from Lloyd's. Now, what Lloyd said to her is, well, we can't give you a guarantee that you'll never have to work with those two individuals in the future. It's just impossible to do that. But what we will do is make every effort to ensure that doesn't happen. But we were not able to say to you that we will give you a severance payment based on enhanced redundancy terms if that situation does ever arise, because your role wouldn't be redundant. The reason for termination of your employment wouldn't be redundancy, so we can't offer those severance terms to you. So they refused to give that undertaking. So Mrs. Hill brought a claim for disability discrimination on the grounds of failure to make a reasonable adjustment. And what she said was the fact that Lloyd's wouldn't give her that undertaking meant that she was placed at a substantial detriment compared to a non-disabled person, because she was in this constant state of fear, worry and distress, because she was always concerned about the future and the fact that she might have to work with those two individuals in the future. So what was the decision? Well, a really interesting one. The Employment Tribunal reached the view that because Lloyd's had kind of refused to give Mrs. Hill an undertaking, they said, well, Lloyd's had a practice of not giving undertakings of those types. All they did was give words of comfort, but they had a practice of not giving undertakings of those of that type. So that practice, the fact that they didn't give those undertakings, placed Mrs. Hill at a substantial disadvantage because she suffered such high levels of stress and anxiety that individuals who were not disabled would not have experienced, and therefore if Lloyd's had given that undertaking to her that she wouldn't have to work with those individuals or she would get the severance payment, that would have alleviated that disadvantage. And therefore it was a reasonable adjustment that Lloyd should have given the undertaking to Mrs. Hill. And they made an award of £7,500 to Mrs. Hill as an award for injury to feelings. But what's really interesting in this case as well is you'll know that the Tribunal have a right to make recommendations. So the Tribunal also went on to make a recommendation or suggested a recommendation that, and I'll tell you the wording of the recommendation because it in itself is very interesting. What the Tribunal said is that Lloyd should give an undertaking that they undertake to ensure that the claimant doesn't work or interact in any capacity with Mr. B or Miss M, so the two employees that she alleged had bullied her, and that in the event that this was not possible, the respondent and the claimant explore suitable alternative employment with the respondent, and if this fails, the respondent uses its best endeavours to ensure the claimant can leave the respondent with a severance package equivalent to its redundancy payment scheme applicable at the time of her departure. So you'll see that the wording of the undertaking itself is really interesting, I think. And so both parties then appealed that decision. Lloyd's appealed on the grounds that it wasn't a reasonable adjustment to be expected to give that undertaking. Mrs. Hill and Lloyd's both appealed the wording of the undertaking itself, and the wording of the undertaking was criticised for a number of reasons by the Employment Appeal Tribunal. The fact that it talks about, it doesn't put any sort of timescales on when that undertaking, how long that undertaking is to last for. The fact it talks about both parties using best endeavours to try and find alternative employment, and also the reference to if Mrs. Hill has to work with Lloyd's in any capacity, the Employment Appeal Tribunal talked about that was far too wide, and that the wording of the undertaking just didn't really work. So what the Employment Appeal Tribunal said was, yes, it's a reasonable adjustment that Lloyd's should give an undertaking of some sort to Mrs. Hill, and they then put the case back to the Employment Tribunal for the Employment Tribunal to decide what the actual wording of the undertaking should be. So we don't have the final version of the undertaking as yet, but I think that's a really interesting case. I think when I was kind of preparing for the session today, I was thinking, so what would my comment on that case be? And I've just written down in my notes here, wow. It's a really interesting decision that an undertaking of that type is the kind of thing that a tribunal will say is a suitable or a reasonable adjustment that an employer should look at making in circumstances like those. And the case kind of talks about, or it demonstrates, I guess, the lengths that a tribunal will go to in order to determine whether something's a reasonable adjustment or not. And I think, what it does demonstrate is that if you find yourself in a situation like that as an employer, you really have to give proper consideration to any concerns, provided they're genuine concerns that an employee who's suffering from a disability raises. And reasonable adjustments come in all different guises. That's quite an unusual one to be asked to give, but you'll see then obviously the tribunal have determined that it was reasonable in the circumstances. It's not specifically referred to in the decision, but I imagine the size and the resources of Lloyd's was probably one of the factors that was taken into account by the tribunal in reaching that decision, so something to be aware of. But I think it does show that direction, that direction of travel, where tribunals are more likely than not to decide that something is a reasonable adjustment if there's any sort of dubiety there. So an interesting case to be aware of, I think. Finally, for this section, the third case that I'm going to talk about is anonymous witnesses. So this is a case of Tari Unlimited against Christie. And the question here is, was a dismissal based on anonymous witness evidence unfair? So what are the facts here? Well, Mr. Christie worked for a housing association, and he was dismissed after one of the tenants of the housing association alleged that he had made homophobic comments. Excuse me. So what happened was the Housing Association carried out a disciplinary investigation. The tenant was interviewed twice as part of that investigation, but asked if they could remain anonymous because they suffered from anxiety and they didn't want to be part of the process. So they were interviewed as part of the investigation. The tenant wasn't interviewed by the disciplinary chair at the disciplinary hearing, and Mr. Christie appealed against a decision to terminate his employment on the grounds of gross misconduct, and the tenant declined to give evidence at the appeal hearing as well. So the only point at which, the only point at which the tenant had given their evidence was in these two investigation meetings as part of the investigation process. At no point was Mr. Christie given the opportunity to look at any statements that had been given by the tenant, and so the kind of concern there was, well, how can he respond to the allegations if he didn't know who made them? And also, it's obviously quite a serious decision to take, to dismiss someone based on an allegation that's been made anonymously, where there's no opportunity at all to test the credibility of that allegation that's been made. So the Employment Tribunal decided that the decision to dismiss was unfair. And what they said was it was unreasonable to simply accept the tenant's account of what had happened when the tenant had refused to provide any further additional evidence. However, when that was appealed to the Employment Appeal Tribunal, the Employment Appeal Tribunal took a different view. And what they said, and this is I think this is really interesting if you are in this situation where you've got some sort of anonymous allegation. What they said was there needs to be logical and substantial grounds to find an employer cannot accept the evidence of an anonymous witness as truthful. So rather than the burden, if you like, being on the employer to show, rather than the burden being on, I guess, the person that's made the allegation that it's true, what the Employment Appeal Tribunal was effectively saying is, unless there are logical or substantial grounds to question what's been given to you anonymously, then it's fair to accept any anonymous witness statement as it is, which obviously is favourable for an employer then. If an employer is going through an unfair or a disciplinary hearing based on an anonymous allegation, it supports the employer's position. However, I think there's a number of things to take away from that, and what the Employment Appeal Tribunal decided as the outcome to that particular case was that the case had to go back to the tribunal for a full rehearing, which is probably the worst case scenario for all parties involved. But they made a number of points about, you can dismiss an employee based on anonymous evidence. That can be a fair dismissal, but as an employer, what you would seek to do is take as many steps as you could in order to try and secure the fairness of the process as much as possible. And the kind of things that they suggested in the tribunal decision would be, for example, the chair of the disciplinary hearing being given an opportunity to interview the anonymous witness. So even if the person against whom the allegation has been made doesn't get the opportunity to know who the witness is or to put questions to the witness, if the chair gets that opportunity, that enables the chair to kind of weigh up the evidence that's been put before them and to determine the credibility of the anonymous witness as well. So if possible, if the anonymous witness will speak to the chair, then that's one thing that you should look to put in place. And the other step that the tribunal decision talks about is ensuring that you're sharing a version of the witness statement with the employee against whom the allegation has been made. Now, obviously, that will have to be redacted. In some situations, it may be that it's impossible to redact it and still retain anonymity. But if it is possible to redact the statement so that the employee can understand the context in which the allegation has been made, even if they're not allowed to know who's made the allegation, then that will help to secure that fairness as well. Okay, so those are the sorts of things to think about. And in terms of whether or not an employee can be a witness can be anonymous or not. The sort of key factors, again, that tribunals look at is, well, what is the reason why the employee or the witness wanted to remain anonymous? And if you can show, for example, they're concerned about their safety or they're suffering from anxiety, as was the case in this situation, those are the sorts of reasons it would be acceptable for a witness remaining anonymous through a disciplinary process. Okay, I'm just going to pick up on a couple of questions here, Morag, before I hand over to you. I think there's one on the unreasonableness. So would there be an obligation on an employer to ask questions that the employee wants to ask, provided reasonable? Yeah, I mean, again, it's another way of dealing with it. So I think the point that you're making there is, if I'm the employee and an allegation has been made against me, but I'm not allowed to know who made the allegation, can I say to the chair, well, these are the questions that I would like the anonymous witness to be asked? Absolutely. And again, it's a helpful way to try and maintain that fairness of process as much as possible. So by giving me the opportunity to put questions to the disciplinary chair to ask to the anonymous witness is another way that you can try and make the process as fair as you possibly can in those circumstances. I mean, in these sorts of cases, as an employer, what you have to be able to demonstrate in tribunal is that you have done as much as you can to make the process as fair as possible. So if you can show that you're looking at all of these different options, but ultimately at the end of the day, the witness still wants to remain anonymous, then that will certainly help you to demonstrate that it was a fair dismissal if you've considered as much as possible how to make the process as fair as possible. Okay. Right, Morag, I'm going to hand over to you for virtual tribunal top tips.
Okay, thanks, Mo. Okay, so we thought this topic might be quite timely. We certainly are seeing cases now being listed for virtual hearings, which hasn't really happened at all to date, and we expect that to ramp up significantly over the coming weeks and months. The Tribunal's been doing a huge amount of work behind the scenes to get judges and members trained up on their cloud video platform, and the roadmap which the tribunals in England and Wales and Scotland issued in June certainly foresaw that over July and August there'd be a big increase in the number of cases being listed for virtual hearings. So we expect to see that starting to flow through. I think there will also be an increase on hearings that will take place in person, albeit socially distanced. So I thought it'd be helpful maybe just to give us or to give you some kind of top tips as we see them in the event that you are involved in any virtual hearings. As Morag said, we think virtual hearings, they're here to stay now. You know, the Courts and Tribunal Service had already got the cloud video platform technology. It just hadn't been rolled out. And as with many things, the pandemic has thrust upon us. We've kind of fast forwarded, I think, probably 5 to 10 years worth of kind of progress on that front, and here we have it. We're being forced into it now, so possibly, you know, not a bad thing in that respect. So the roadmap that was issued in June set out that in July and August there'd be kind of increase. The Tribunal Service is using, as I said, the cloud. It's called the Cloud Video Platform, also referred to as CVP. So it's quite similar. It'll be a very familiar kind of setup platform to you. It's very, very similar to this WebEx and to Zoom. It's pretty straightforward, pretty user-friendly to use. So in terms of our tips in the event that you are involved in, we are seeing a bit of an increase in tribunal claims, and we expect that only to continue with many employers across the UK now making redundancies or otherwise changing terms and conditions of employment, and indeed tribunal cases coming out of furlough and arrangements that were used by employers to put that in place. So first and foremost, the tribunal always retains kind of a final say over whether a particular case is suitable to be used for a remote hearing. As part of that process, you will most usually be expected to participate in a telephone case management conference call to talk about how a remote hearing might work and if it is suitable in the particular case. As part of that, if we're involved in acting for you, we will come to you in advance of that to check whether a remote hearing might work for you and for all of your witnesses in a case. It's really important that everybody participating from a particular party's side has got the necessary equipment and a good, strong internet connection. If there are any doubts on that front, that would tend to point to it not being a case it would be appropriate for a remote hearing. So you can expect that when we are talking to the Tribunal about that, we'll be liaising with you to make sure that you're clear on what everybody needs to be set up for a remote hearing, and that all of your witnesses are in fact set up in that way. If they're not, then as I say, it might be one for an in-person hearing, and again, there may well be delay because of that. So the CVP platform, similar to Zoom, it's browser-based, so all you need is an internet connection and a web-based browser. Google Chrome is the best in terms of compatibility for sound and for visual quality. CVP doesn't work with Firefox or Internet Explorer. It does work with Microsoft Edge, but only to the extent that that is a post-February 2020 version. So if it's CVP, you'll be wanting to make sure that you and your witnesses are all set up with Google Chrome. Key restriction on remote hearings is that you must not record or broadcast or comment on remote hearings using any live text-based comms. So, for example, Twitter or Facebook without the Employment Tribunal's consent. If you do that and you don't have consent, you risk a cost or expenses order, a prep time order, potentially having your claim or response struck out, and in a worst case scenario being held in contempt. So that's an absolute no-no if you don't have the consent of the Employment Tribunal. In terms of equipment that you'll need, either a smartphone or a tablet or a laptop or a PC, ideally with as large a screen as possible. It just makes it so much easier to see everybody who's participating. I think on CVP you can see up to 16 people, so it's more than you would have, for example, on your kind of typical Zoom call. We find it's quite helpful if you also have a second screen, so that CVP is not set up to allow sharing of documents. So your, for example, your bundle of tribunal documents. So you will either want the tribunal to have physical copies of those sent to them. We would suggest at least 3 days, possibly a bit more in advance, to allow them to leave the bundles sitting for 72 hours to reduce any risk of infection. So you'll want physical copies sent through to the tribunal, or by way of PDF, but these are things that would be discussed in any telephone case management discussion in advance of that, but also to make sure that your witnesses have got access to either a physical or a digital copy of the bundle. Having a second screen can make that so much easier, so that you can email a PDF of the bundle through, and your witness or you indeed can sit with that open without being distracted from the CVP platform. Next tip is that there will always be a test. If your hearing is listed to be a remote hearing, the tribunal will conduct a test with you in advance of that, normally just a few days in advance. So each party will have its own separate test, but each party must participate on that, in that, with all of their witnesses. If not everyone from each party side participates on it, the tribunal may take the view that it's not appropriate for a remote hearing. So just, we will obviously, if we're involved, we'll let you know and keep you appraised of what the arrangements are for the test hearing, but it's really crucial that you and all of your witnesses participate in that. Doesn't look great from the Employment Tribunal's perspective if you can't get your own witnesses to turn up to that, let alone the hearing itself. Next tip is that remember that although it's a remote hearing, it's still very much a formal Employment Tribunal hearing. So do behave and do dress as if you're attending an in-person hearing. We've seen some quite amusing examples of that. I haven't seen any from within the UK. They've been tended to be from that place across the pond. But do remember that even though it's being done remotely, it is a formal Employment Tribunal hearing. have a think about where you will participate in it from. So each party and each witness should be somewhere private, somewhere quiet, where they're not going to be disrupted, where there's an appropriate background. And I know of someone who recently participated in a court hearing where the judge actually had covered up, I don't know, there was a bookshelf or behind him, but actually placed a kind of white sheet on it. So make sure that you've got an appropriate background. Only have one device on in the room to reduce feedback, and ideally, as many of you have here, use headphones or a headset to reduce that kind of background noise, which can be extremely distracting. Normally what we'd always do in advance of, and what we do actually for these webinars is we set up a separate way of communicating with the others on your side during the hearing so that we can take instructions and liaise with witnesses. What we would tend to do is use WhatsApp for that, so that you've got a way, there's no private chat room facility within CVP, it's all public. So to enable us to be able to take instruction from you, we would generally set up a separate means of communication, either through text or WhatsApp, so that we're able to liaise with you. And we'll generally have a separate one also with the solicitor on the other side, and then potentially also a separate one with all of the witnesses. Really important, and more for something for us to worry about rather than you, that we label them so that we know clearly who we're talking to, and we're not we're not liaising with the other side when we think we're taking your instructions and such like. But those can be really helpful, particularly, as I say, when there's no kind of private chat room facility. As on all of these calls, and I think, we're so good at doing them now, we've been exposed, we've done them in a way that we've never, done before until these last, few months, is obviously, the usual call etiquette that when you're not speaking, you put yourself on mute, you turn off your mobile phones, make sure they're on silent or in vibrate mode only. Be very wary of your body language. I think sometimes you're lulled into a bit of a false sense of security that, you've been done remotely, but actually, on some of these platforms, there are fewer people on it. You appear much bigger on screen actually, and much closer, kind of virtually. So watch your body language, eye rolls, head shakes, other gestures. They can all be picked up upon very easily when your camera is on. So just remember, if you don't want to be seen, turn your camera off. But otherwise, just to be mindful of that. And I think lastly, I would say is that I'm sure you would agree with me that when you're on video calls or you're speaking virtually, and particularly in the context of a formal hearing, particularly if you're giving evidence, that's very intense in person, even more intense when you're doing it virtually on a platform that you're perhaps not familiar with, if you're perhaps not given evidence before. The tribunal will be very much alive to that, and you can expect that there will be more regular breaks than there would be at an in-person hearing. Needless, so it's a kind of quick canter through the kind of key tips for virtual hearings. Needless to say, we're involved in those, we make sure that all of our clients and our witnesses are fully prepped on what to expect, so that we're limiting any scope for surprise. And certainly the employment tribunal staff are great and very, very helpful. And as I say, the platform itself is pretty straightforward. So anybody, you all being on this call would have no problem using for early conciliation, or is that separate? So that's separate process, that's run through ACAS, not the Employment Tribunal Service, and that's just continuing as normal, principally by phone or by email. I haven't done any video calls with ACAS. I'm not sure they would have the facility, to be honest. I don't know why it would be necessary. We've always done just work over the phone with them or by email, kind of rather in person. Is there an intention to record hearings where virtual? Yes, I don't think, not every hearing will be recorded. I think that is the plan, but I don't think there's full functionality on the platform at the moment, but I think the intention is that there will be an audio recording and that will be able to be requested, which would be, helpful, for example, for appeal purposes. But I don't think that will automatically be the case. So if that's important, that's something that we'd be addressing on a case-by-case basis. Will a hearing take longer or more days? Yeah, I think that's likely to be the case. I think the guidance from Scotland have issued their own practice direction and guidance on remote hearings. It's really useful, and that does make clear that people will need to be patient. It's expected that there will be teething difficulties as people use a platform that they're not familiar with. There will, as I said, there'll be need for more regular, kind of shorter breaks. So I expect with both of those things, yes, the likelihood is that hearings will take a bit longer than they otherwise would do.
Morag, do you think there'll be more use of witness statements then in virtual hearings?
Yes, I mean, that's been suggested. So you'll know, of course, that in England and Wales, it's the norm for witness evidence to be given by way of a pre-prepared statement. That's not the case. That's not been part of the judicial tradition in the employment tribunals in Scotland. But the practice direction and guidance does refer to that to say, yes, that may change. That may now change. Given remote hearings, to try and keep the proceedings as efficient as possible. And again, that's something that and to be honest, we've seen a wee bit of a trend of that over the last few years, I would say, particularly for longer running cases that are expected to run for a bit longer, or who have a large number of witnesses, perhaps involving slightly more complex legal issues and discrimination, for example. So we have seen a bit of that in Scotland anyway, but yes, they do signpost that to say that they expect that there will be an increased use in written statements here.
And I take it as well, just going back to the conciliation question, there's an intention, I think, as well, to do judicial mediation virtually, to offer that service too by the employment tribunals. I know a couple of our colleagues have done non-judicial mediations, kind of private mediations virtually now since March, and they've worked well. So I expect that'll be the same with the tribunal service. Is that right?
Yeah, that's right. And most of the kind of main mediators that we would tend to work with are set up. Views differ as to, which platform to use, etc. I've been aware of mediations taking place by Zoom. Often the premium account for Zoom, which allows you to set up separate rooms so that you can kind of chat in private. But certainly on the mediation side of things, that they moved quite quickly to being done remotely as soon as we went into lockdown. And certainly from the tribunal's perspective, in terms of judicial mediation, it's quite clear that they anticipate the same happening from the tribunal's perspective. And we've had cases where it's worked really successfully. Actually, people have been slightly surprised just how easy it seemed. I think the one piece of feedback was that it was pretty intense, particularly when you've got different rooms, and you might have you've got a private room with you and the mediator, and then you've got a separate room for the lawyers to liaise, and then you might have another one yet again, and keeping on top of which rooms which. So I think that was the key difference, actually, that it was even more intense. Perhaps not dissimilar. We had our own kind of partners catch up this morning, and we've moved to this world where our firm is operating virtually at the moment, and that's very much informing what we'll do in the future. But the one piece we can't forget is that it's actually so much more intense than going into an office environment and you having natural breaks of popping to the loo, popping to get a tea or a coffee, bumping into someone. So in the same way as that, many of us are feeling it quite intense at times to be working from home, that we see that translating into kind of other kind of virtual settings as well, as far as mediation and hearings are concerned.
Yeah, it's interesting. Well, it's interesting to know that the tribunals see this as a long-term thing and not just temporary as we get through the current situation. So definitely something, I think, for those of you that are in a tribunal situation, or you're kind of helping witnesses who are involved in tribunals, it's something that they really needs to be taken into account now, I think, how you approach virtual hearings. Was there anything else, Morag, just before I head on to
that was
COVID-19
everything. Yep,
developments?
no,
Okay.
that was everything for me. Yep.
Right, just briefly on COVID-19 developments then, not a huge amount. The point about furlough grant and notice period, obviously there was a bit of a panic about that for a while, understandably so. There was a school of thought that the way the guidance was issued, you couldn't reclaim the furlough grant if you had issued someone with notice of termination of employment. You would have to pay that notice period yourself. That confusion was created because of the way the guidance was drafted, and then it was a change to say that you could claim the grant while someone was on statutory notice. So then, of course, that caused confusion, because what about if you had someone on contractual notice? But the guidance has now been changed to confirm that you can still claim the grant once someone's been issued with notice, whether they're working their statutory notice or their contractual notice, if their contractual notice exceeds their statutory notice. So good to have that confirmed. I know it was a question quite a few people were contacting us about. Last week, of course, we had the new legislation to make it clear that any statutory redundancy payment should be calculated based on the individual's normal salary rather than any furlough reduced salary. So just to ensure that the employee receives the statutory redundancy payment that they would have received had they not been on furlough at any point. So that's helpful as well, I think, to have that clarity. We've now got the information from HMRC as well about their ability to reclaim any grant payments if they've been overpaid, and the ability to issue penalties as well. So if you have claimed too much of the furlough grant, by accident through calculations that you've done, in the following month you can notify as part of your next month's claim that you feel that you overclaimed the month before, and that'll all be resolved. So it's quite a useful mechanism to try and ensure that you don't get yourself into a situation where you're having to pay penalties as a result of overclaiming the grant. I think when you look at the note the HMRC published on that, there's a clear priority in terms of using those powers where people have knowingly, fraudulently claimed the grant rather than it being mistakes that have been made. The other big development, I still can't really get my head around it and the purpose of it, but is the bonus, the job retention scheme bonus payment, this £1,000 that will be paid if employees are still employed at the end of January. I do understand that the reason behind it is to obviously try and encourage employers to keep individuals on until the end of January. But there's a number of conditions to payment of the bonus. I'll just quickly run through these with you. The first is that the individual has to obviously have been furloughed at some point between March and the end of October. But it would seem that even if they've just been furloughed once for 1 3-week period, that will be enough for them to have the bonus payment in January. The second condition is that they have to be continuously employed from the last time that they were furloughed through to at least the 31st of January. The third requirement is that they have to have been paid an average of not less than £520 a month between November and January. Now, it doesn't mean that they have to be paid £520 each month. It's just an average of £520 over that period of time. And then the fourth condition is that you have to have up-to-date real-time information records for that individual for the period up to January. And finally, you can't have served notice of termination of employment for that individual before the 1st of February 2021. So that's the key conditions of the bonus payment being made. And you can apply for the bonus payment with effect from the 1st of February 2021. Okay, so that's the bonus. And then the last point I just wanted to cover on COVID was statutory sick pay in the various categories that now apply. It just becomes more and more complicated, but the government have made it clear that if you are asked to self-isolate as a result of the track and trace system being in play, then you are entitled to statutory sick pay. As a result of the shielding category effectively being brought to an end from the 1st of August, individuals who were shielding previously are no longer entitled to statutory sick pay if they remain off work. Unless, of course, they end up off work because they're suffering from ill health, separate to the fact that they were shielding simply for COVID-19 reasons. And the other category, those individuals who have to go into quarantine for a period of 14 days after return from holiday, are not entitled to statutory sick pay either. So it's a topic to keep an eye on because it changes, if not daily, but really weekly. So they're the key kind of developments in relation to COVID. And then just briefly on the other news that I'd picked up that I thought it was worth telling you about. Interestingly, because there was no requirement to publish gender pay gap this year in light of COVID-19, the statistics out that only 50% of employers who otherwise would have been required to publish their pay gap have done. So I thought that was just quite an interesting statistic. In terms of legislation, a couple of things. For those of you in the public sector, you'll have seen the government has responded to the consultation on public sector payments on termination of employment, and they're proposing that a cap is put in place so that any individual who exits public sector, a public sector employer, there's a cap on the severance payment of £95,000. That's expected to come in at some point this year. And then the other development from a legislation perspective, although still some way off in the future, is there's a proposal to introduce an entitlement to neonatal leave. So if you've got employees who whose child ends up receiving neonatal care, then they would have an extra entitlement to leave over and above their maternity leave entitlement there. It looks like that's going to be 2023 before that's brought in. And then I just wanted to flag for you finally, three key areas where we're expecting Supreme Court decisions, or a date has been listed for Supreme Court hearings. The first one is the FOB case, which some of you may have heard us speaking about before. This is this issue about the burden of proof and discrimination claims, and where does the burden of proof lie? I've spoken before about it's like a game of tennis. The ball starts in the employee's court. They have to demonstrate that there's a whiff of discrimination, and then the ball transfers into the employer's court to show that discrimination didn't take place. That view was kind of thrown up in the air as a result of the FOP decision, where a judge at Employment Appeal Tribunal level said, no, the ball doesn't start in the employee's court. What happens is you just look at all of the facts, and then based on all of the facts, you decide whether there's enough for discrimination or not. That decision was overturned by the Court of Appeal, so it went back to, no, it's for the employee to demonstrate that there's a whiff of discrimination before the ball goes into the employer's court to show that there's not discrimination. That issue is now to be subject to a Supreme Court decision, and it's been listed for March next year, so that's going to be quite an important decision when it comes out. The other one some of you will heard of us talk about, the Costill case, which is the unlawful inducement case. That's the case where the employer was in negotiations with the unions about pay rises. They couldn't reach agreement. So what they did was they said to employees, right, we'll pay you this Christmas bonus if you accept the pay rise. And that, on the face of it, looked like an unlawful inducement to kind of get round the trade union negotiating mechanism. That decision is up for hearing at the Supreme Court in May next year. So if any of you have union or working in unionised environments, that's an important one for you. And then the third category, holiday pay, of course. There are three holiday pay cases that are likely to be held by the Supreme Court. We don't have a date for that yet, so I imagine it'll be kind of summertime next year. But looking at three topics: voluntary overtime and whether that should be included for the purposes of holiday pay. The way the case law stands at the moment, yes, it should. How you look at this 3-month gap when you're determining whether there's been a gap that's long enough to break the continuity for a holiday pay claim, and also issues around about part-time working and holiday pay. So just so you know, that's going to be quite a significant decision that's likely to come out as well. Oh, right, that's you, bang up to date.
Okay, a couple of questions more.
Yeah, oh no.
Yeah.
Yeah. Go for it.
Am I right in thinking that where variable hours, that redundancy pay would be based on average income prior to being furloughed?
Absolutely, yep, spot on.
And if you're required to self-isolate prior to an operation, should this be considered as paid leave?
So if you're self-isolating as a result of track and trace, then you would be entitled to statutory sick pay. Obviously, if the self-isolation is nothing to do with the operation, so you're not ill and then having an operation, you're just being asked to self-isolate, then you would be entitled to SSP. If you are ill prior to the operation and you'd be treated in the normal way, somebody would be on sick leave. All right. Right, I'm going to conclude there, if that's okay. I'm just conscious of time. Next planned session will be probably October, but as I say, if there's any key developments between now and then, we'll get a session set up. The other thing I just wanted to mention is we're rerunning the course that we did back in July, which was kind of getting your business ready for the new world, if you like. So we looked at, there was 5 sessions each lunchtime, 1 till 2 o'clock. The first session on collective consultation, the second on individual consultation, the third on change in terms and conditions, the fourth on TUPE, and the fifth on the new working environment, looking at things like data protection issues, etc., health and safety issues, and policies and procedures. So we're running those week commencing the 17th of August. It's £75 a session, and you get, obviously, participate in the live session, you get a recording of it as well, but we also give you kind of key documentation that you need to be aware of or that would be useful for you under each of those headings. So I know Emma's posted a link there to the details for those sessions if any of you are interested in those, or you can just pick up with Morag and I as well. And that's it. You can all breathe a sigh of relief and either go and have your lunch or go and have a wee lie down before you start back up again at 2 o'clock. All right, thanks as ever for everyone for joining today, and we'll speak to you again soon. Take care.